The Fourth Circuit just struck down the federal handgun ban placed on 18 to 20-year-olds. So let's talk about this. So I just want to thank you guys real quick for everybody who watched my last video, who subscribed to my channel over the last 2 years and who subscribed off that last video. I tried to comment back to as many of you as I could on that last video. And for those of you who are not aware, I'm rapidly approaching the 2-year anniversary here on YouTube. I have a goal of trying to reach 150,000 subscribers. So if you guys see value in these videos, if you watch my videos, I would greatly appreciate if you do subscribe to my channel. And also if you subscribe and you're a new subscriber, go ahead and comment down below in the comment section and I will try to respond back to you. So thank you all again. I am so happy that I've got to spend these last 2 years with you guys. I'm looking forward to so many more videos and years with you. So in this video, we're gonna be talking about a Fourth Circuit Court of Appeals ruling that recently found that the federal laws prohibiting 18 to 20-year-olds from purchasing handguns from gun stores was unconstitutional. This is a federal law that's been in place since 1963. Congress enacted it, and since then, 18 to 20-year-olds have not been able to purchase handguns from gun stores. They can go to war, they can get married, they can enter into contracts, all of those things, but they cannot go and purchase a handgun. Well, the Fourth Circuit just found that that federal law is unconstitutional. So let's take a look at this ruling, let's see what they said, and kind of talk about some of the implications that this case could have. So at a general level, this case is a challenge to the federal laws which prohibit 18 to 20-year-olds from being able to purchase handguns from gun stores. And specifically, the plaintiff in this case is 19-year-old Natalia Marshall, who was in an abusive relationship with an ex-boyfriend. She had a protective order against this individual, and she wanted to go purchase a handgun from a gun store, but couldn't because of these federal laws. Now, procedurally, what happened at the district court level, which is the kind of base trial court level, ultimately, the plaintiffs in this case, Natalia and her representative, sought a summary judgment motion, and then the ATF, who is the defendant on the opposing side, sought a motion to dismiss. While the Virginia District Court reviewed the case, reviewed the motions, and actually found against the motion for summary judgment, which was the plaintiff's motion. So they got rid of that one, and then they granted the ATF's motion to dismiss. So ultimately they found in favor of the ATF and found against Natalia. Now, this denial of the plaintiff's motion for summary judgment and the grant of the ATF's opposing motion to dismiss was then appealed up to the Fourth Circuit. And so this went before a 3-judge panel in the Fourth Circuit. The judges that issued this ruling were Agee, which was a Bush nomination, Wynn, who was an Obama nomination, and then Richardson, who was a recent Trump nomination. Now, the main thrust of all the arguments and discussion that happened out of this case was whether or not 18 to 20-year-olds were actually covered under the Second Amendment. Do they have a Second Amendment right? And a lot of this analysis actually happened by them looking at what were the traditional militia, were 18 to 20-year-olds included in the militia back at the founding of our nation in the writing of the Second Amendment? Who are the people considered to be in the actual Second Amendment, the reference to the right of the people to keep and bear arms shall not be infringed? What is that in reference to? And then there was also some analysis about the age of majority and how does that play into this, being, hey, the age of majority we have right now is 18-year-olds to go, join the military, to enter into contracts, to be married. But historically, traditionally, what was that age of majority and how should that play into here? So first and foremost, there was a discussion about the militia and how does that reference to the militia play into this whole issue of 18 to 20-year-olds. And ultimately, the argument of the court here is that the militia is a reference to a subset of the people. And so here are some quotes from this actual opinion. The court stated that near the time of ratification, the federal government in every state required 18-year-old men to be part of the militia and bring their own arms. This evidences that the founding public's understanding that the militia, and thus the Second Amendment, encompasses 18-year-olds. Every militia law near the time of ratification required 18-year-olds to be part of the militia and to bring their own arms. So here they're going back into the historical context of what the militia was at the time of our founding, at the time of writing of the Second Amendment, and what did the militia encompass? And here they conclude that the militia included 18-year-olds, and those 18-year-olds were not just part of the militia and then were given firearms when they participated in the militia, but actually, in fact, those 18-year-olds were called up to join the militia and were actually called to bring their own arms, which they already possessed. And then there is some discussion about who are the people, and the people are just simply every single person in the US who is a citizen of the US, and simply the militia is a subset of those people who are called to arms. Now, there was also some discussion, like I mentioned, about the age of majority. And the ATF argued that the age of majority at the founding times was 21 years old, and therefore this prohibition on individuals 18 to 20 right now currently from being able to purchase handguns from gun stores is in fact valid and is constitutional because it adheres to the historical context of our founders. Here the court essentially rejected that argument, and they stated that but the age of majority, even at the founding, lacks meaning without reference to a particular right. They go on to state that a woman could consent to marriage at age 12, choose a guardian at age 14, and serve as an executrix at age 17. Both sexes had to wait until 21 to dispose of their lands. So here the court is sort of rejecting the broad swath of age requirements, saying, hey, 21-year-olds back then could not sell their own land, so that's when the age of majority is. They're rejecting that, and they're saying instead you need to look at the actual right in question, here being the Second Amendment right, and then look at the history and context surrounding that. And like the court said prior, 18-year-olds, 19-year-olds, 20-year-olds could be part of the militia. They could possess firearms while in the service of militia, and in fact were called to bring their own firearms in service to the militia. Now I want to read to you the conclusion of this judgment because I think it sums up well what's kind of going on in this case. So this is coming directly from the court. Those of good faith on both sides of the gun debate wish to protect lives and uphold individual rights. We appreciate the seriousness of gun violence in this country and applaud Congress's laudable desire to curb senseless violence. But we also recognize that the Second Amendment embodies a fundamental, pre-existing right that enables the people to preserve their own life, liberty, and property. Striking a balance between those interests is a difficult exercise that draws intense passion on both sides, and that is for a good reason. But while Congress or judges may have struck a different balance long after ratification, that role is foreclosed to us by the balance that the founders chose. We cannot now second guess or undermine their choice. History makes clear that 18 to 20-year-olds were understood to fall under the Second Amendment's protections. Those over 18 were universally required to be part of the militia near the ratification, proving that they were considered part of the people who enjoyed Second Amendment rights, and most other constitutional rights apply to this age group. And Congress may not restrict the rights of an entire group of law-abiding adults because a minuscule portion of that group commits a disproportionate amount of gun violence. Congress's failure to connect handgun purchases from licensed dealers to youth gun violence only served to highlight the law's unduly tenuous fit with the government's substantial interest. 18 to 20-year-olds have Second Amendment rights, and the challenged laws impermissibly burden those rights. As a result, we vacate the district court's grant of the motion to dismiss, reverse the denial of summary judgment, and remand for further proceedings. So that is the conclusion of their judgment here, and that is what they are ordering. So what are the impacts of this Fourth Circuit ruling? Well, at a surface level, the Fourth Circuit reversed and remanded this case back down to the district court. However, there will likely be a motion for a rehearing en banc in the Fourth Circuit. Now, what does that mean? Well, an en banc rehearing is essentially a review of the three-judge panel's decision here by a larger number of judges. In the Fourth Circuit, there are 15 active judges with a slight lean towards Democratic nominations. And essentially what happens is all 15 of those active judges will now review that decision by the three-judge panel. Even if this wasn't appealed for a rehearing en banc and it was actually remanded back down to the district court, this would only affect primarily the Fourth Circuit, which covers states like Maryland, North Carolina, South Carolina, Virginia, and West Virginia. So those are the states that this has an immediate impact on. But there are some other kind of impacts and implications as well. Of course, if this made it up to the Supreme Court, that would affect everybody if there was a pro-Second Amendment ruling by the Supreme Court, because that is binding precedent on all circuit courts. But there's also some implications for other circuits like the Ninth Circuit, which the state of California is under. When it comes to the Ninth Circuit and some of the cases that the Ninth Circuit may be addressing, like the Jones case, which deals with California's prohibitions on 18 to 20-year-olds from being able to purchase pretty much any firearm, when it comes to that, this decision is persuasive precedent, but it is not binding precedent. This is only binding precedent as far as it is upheld in the Fourth Circuit, but other circuits and other cases can point to this decision. So if you guys have any questions, go and comment down below and I'll try to answer the best of my ability. Also, Also, if you guys like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm. It helps to signal to YouTube that you guys see value in these videos, and then it pushes it to more individuals who want to hear this type of two-way news. Like you guys probably saw in the last video, a lot of you were commenting down below that you were commenting to fuel the algorithm, and that really did have a huge impact on pushing that video to more individuals. So thank you guys so much for doing that. Go ahead and drop a comment down below to fuel Al Gore's rhythm if you prefer to fuel Al Gore's rhythm instead of actually fuel the algorithm. I really appreciate that, and thank you. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this station was built by armed scholars and station will be maintained by armed scholars.